Oh, this sounds like legal submissions. SMS Edwin Tong.
Thank you, Mr. Deputy Speaker. So I thank the members for the comments and the wide-ranging number of suggestions and queries that have been raised. And I will do my best to respond to them, also in the framework of the two broad baskets of revisions that have been introduced in this bill. Let me start with queries on Clause 5 of the bill. And as Mr. Ng and Mr. Pillay, I think also Mr. D'Souza noted, they shift matters which are non-appealable in Section 34.1 to the 4th schedule, and those which are appealable with leave from 34.2 to the 5th schedule. Mr. Ng in particular sought query on why that was being proposed. First, the amendments, as I said earlier, seek to consolidate all of these into one place. At present, you can find matters which are referred to or necessary for leave to appeal in the main body of the statute and also in the schedule. And likewise for the matters which are non-appealable, also appearing in both places. So the first objective of these amendments is to put them all into one location, so that the schedule itself, the 4th and the 5th, will house all the matters for which it is either non-appealable or appealable only with leave. Second, moving them into the schedule does allow for more flexibility and speed. And as the members will know, it takes more time to amend the primary legislation than it will be to change the schedule. And the schedule will be revisited from time to time and added to or removed from by the minister in consultation with the Chief Justice. So it is not just the minister alone who will decide on what goes in or what comes out of the schedule. Mr. Ng did raise a concern as to whether the schedules will remove the items going in or coming out from Parliament's oversight. The minister ultimately is accountable in Parliament to all members, and this would apply to the decisions as regards what goes in or comes out of the schedule. And to the extent that there are any issues to be raised on this, Parliament can be the forum for this to be raised. On a related note, Mr. D'Souza did question as to whether there's a change in a policy rationale as to how a matter or the basis on which a matter is classified as non-appealable or appealable only with leave within the SEJ framework. I thank Mr. D'Souza for allowing me to clarify that the policy rationale in deciding whether a matter is classified as one or the other, non-appealable or only with leave, has not changed. Matters are and will continue to be carefully differentiated based on their importance to the substantive outcome, and quite importantly also balance against the appropriate allocation of judicial resources to deal with those matters. Mr. Pillay queried why the power to amend the schedule is vested in the minister, but the power, I think you referred to the monetary limit under Section 34(2)(a) is not. The reason I think I referred to in my original speech is because it's consistent with Section 30 and 53(2) respectively of the State Courts Act, where it is the President who has the power to amend the monetary limits for the District Court and the Magistrates' Courts after consulting with the Chief Justice. So to that extent, that remains the province of the President, and it finds its place in the main body of the statute, whereas the cases which go into the schedules can be decided upon by the Minister in consultation with the Chief Justice. I turn now to Clause 4 of the bill, which introduces the new schedule, the 6th schedule, which sets out the quorum of the Court of Appeal when exercising civil jurisdiction in matters. Mr. D'Souza asked what considerations may be taken into account when deciding on this schedule. The key considerations would be the appropriate amount of judicial resources, which should be expended on a particular class of matter. Obviously, issues as to the complexity and the novelty of the matters raised will remain high on the list of priority. In fact, as Mr. D'Souza knows, the courts already consider complexity and novelty in deciding when to constitute a quorum of 3 or 5 judges in a court of appeal, as the case may be, for both civil and criminal appeals. For instance, a quorum consisting of 3 judges of appeal would generally not be necessary to deal with matters incidental to determining the merits of the application or the primary application. So, for example, applications which have bearing on seeking security for cost or applying to discharge solicitors, those do not need a full quorum of 3. I turn now to deal with the question of further evidence in proceedings, and I think all 3 members touched on this. Mr. D'Souza in particular asked about the rationale as to why leave will now be required to admit further evidence. I'd like to inform the members that these revisions deal with the admission of evidence, new evidence, in relation to interlocutory matters. So bear that in mind as you understand the concept and the construct of why these rules apply in this way. Most parties, I think members would agree, would have the opportunity of raising all the evidence. We have our hearings now conducted first with extensive exchange of cases in writing, and then the submissions by the skeletals as well, just before the hearing. So several written opportunities would be afforded to the parties already before the hearing itself. And to that extent, the parties are encouraged, and I think quite rightly so, given the limited resources we have for hearing time, to ensure that all the available evidence would be before the courts, before the hearing itself. And so, to that extent, when one is seeking to raise evidence or include further evidence in the appeal, where that evidence was otherwise available to the party before the lower court hearing, then one has to be very circumspect about it. And in those situations, leave would not be granted, or there will be no leave that will be granted because it would not be allowed. This is in contradistinction to those cases where, subsequent to the hearing itself, new matters develop. And in those situations, I think it's reasonable to assume that if they have a bearing on the outcome of the appeal, satisfying the usual test for further evidence, then those cases would be written submissions. Both Mr. D'Souza and Mr. Pillay, and I think Mr. Ng also touched on this question, and asked questions as to why Section 34 Big A2, which allows the Court of Appeal to decide matters based on written submissions, is only restricted to those from the SICC. Mr. Pillay further pointed out that Section 34A1 already provides that the Court of Appeal has powers to decide on matters without hearing oral arguments. Let me first clarify that Section 34 Big A1 only empowers the Court of Appeal to decide any application to it without hearing oral arguments. The scope of this provision applies to potential applications which are ancillary to the main appeal. So as I said in my opening speech earlier, they deal with applications, not the main substantive appeal itself. An example of an application would be, going back to my earlier point, security for cost, or applying to amend a part of the case, or trying to deal with potential costs of the hearing. So those are matters which are ancillary to, but not the main appeal. As a general principle, nonetheless, where oral arguments are otherwise useful to elucidate the issues and to facilitate a just and expeditious disposal of an appeal before the Court of Appeal, those will still take place. That said, Mr. Pillay raised the question of the SICC. The SICC is set up to hear international and commercial matters which involve parties with no substantial connection to Singapore. Given that such matters may involve international parties or foreign registered lawyers, the parties may wish on their own accord to save time by obviating the need for an oral hearing to take place in Singapore. Further, any international judge on the quorum would also not be required to travel to Singapore for that oral hearing. Such a flexibility gives the SICC, or makes the SICC a more attractive option for international parties to settle their disputes, and also add to the already existing suite of party-centric innovations, such as allowing foreign counsel to submit directly on foreign law without it having to be proved through expert evidence. To ensure that this option is only exercised in cases where the parties consent, Section 34 Big A2 provides that appeals from any judgments or orders of the SICC can be decided without hearing oral arguments only if every party to the appeal agrees. So in other words, the choice is made by the parties themselves and not, I think, as Mr. Pillay suggested, by the SICC, which, yes, remains as a division of the High Court. I turn now to the next basket of amendments which deal with controlling vexatious conduct. I would preface my response by reminding members that the power to control vexatious conduct is already present. What is being sought to be introduced in these amendments are broadly two things. One, a gradated approach, so that it is not a one approach in Section 74 of the SCJA as it is presently. And secondly, it is to allow for parties aside from the Attorney General to also make the application. Clause 10 of the bill introduces the new civil restraint orders. They are meant in the first instance to be used in situations where the litigants have persistently initiated proceedings that are groundless and without merit. So the litigant has to do it more than once, multiple times, at least twice in the case of the first rung or the lowest grade of the orders, and also without merit, must be absolutely without merit. These are done often with the purpose of annoying or embarrassing the other party. I wish to inform members that the litigants who have held to be vexatious litigants by our courts have so far been far and few, thankfully. In 2017, only 4 orders were made under Section 74 of the SCJA. To date, no such orders have been made in 2018. The policy intention behind these amendments is, as I mentioned earlier, to allow the courts to have and to be able to make a more nuanced approach in terms of the orders that they make in managing the different levels of culpability of the vexatious litigants. And this allows the judges to have more regard to the individual circumstances of each case and to make those distinctions. Second, in terms of how and when these orders are to be applied, it will be for the courts to carefully consider all the facts and circumstances of each case before exercising their discretion on whether to do so or not. While I will clarify the ambit of each of these restraint orders shortly, the jurisprudence in this area must ultimately be left to develop through the exercise of principled discretion by our judges based on the actual facts and the context before them. And members would wish to note also that this is the position also in the UK. With these in mind, let me address the concerns raised by members which, as I've heard, broadly falls into 3 categories. First, the definition and applicability of each of the civil restraint orders. Second, the procedural details subsequent to the grant of the civil restraint order. And third, the interaction and, as Mr. Pillay puts it, the interplay between the civil restraint orders and Section 74 of the SCJA. Let me start by addressing Mr. D'Souza's concerns that more disputes might arise because of the distinctions that are drawn in the 3 types of civil restraint orders. First, I wish to emphasize that each of the 3 types of civil restraint orders requires a distinct threshold to be met before they can be considered. While some cases may inevitably throw out factual matrix where the type of order or issue is not so clear-cut and not quite so cut and dry, I would say that the courts would be well placed to apply the letter and intent of the law to these new and potentially multifarious situations. And they would do so having regard to the issue at hand, to the party in question, and to the conduct in question as well in each individual case. It may be helpful to consider that these restraint orders have in fact been applied in jurisdictions like the UK, like I mentioned, and as far as we can tell, they have not faced issues with regard to the way in which one might distinguish the type of orders. The factors, I believe, are clear, and they have been considered in previous cases also in the UK. And our courts will no doubt take reference to, although will not be strictly bound by these cases when they have regard to these applications with the specific facts before them in question. Mr. Ng asked what factors the court would consider when deciding whether an extended civil restraint order is sufficient or appropriate, given that a general civil restraint order will be issued if an extended civil restraint order would not be sufficient or appropriate. To answer Mr. Ng's query, one scenario in which the general civil restraint order would be imposed would be where, for example, a vexatious litigant adopts a, and I quote, a blunderbuss approach to litigation. He may bring in a slew of grievances against different parties within a short period of time without focusing on a particular single grievance. And the language that I've just quoted from is from a UK decision applying the equivalent of the statute. This, I believe, gives the court an ability to appreciate, in a particular case, the number of cases that are filed, number of times the court is faced with applications by this litigant, the period of time within which it is done. So, for instance, if you file 5 cases over 10 years, is quite different from 5 cases over 2 months. So the court is able to appreciate that better in the context of the case. The court will also look at whether it is widespread, whether it is indiscriminate, and whether one raises a series of allegations which have basically no legal merit, but beyond that, just takes an approach that seeks to sully the name of a potential party with no reasonable legal basis. So all that comes into the play and comes into the mix. And the flexibility of this approach allows the court to attenuate its reliefs based on the facts of the instant case before it. Next, I'd like to touch on the scope of the extended civil restraint orders under the new Section 73C, a point that Mr. Pillay brought up. I believe Mr. Ng as well raised the question of the scope of the language under the new Section 73C and whether it is intended to be identical to the interpretation the UK courts have taken under the civil procedure rules and the factors that a court should consider in determining whether a new action or application falls under the extended civil restraint order. When construing the new Section 73C, the position adopted by the UK courts may be persuasive, but our courts are not obviously bound to follow the interpretation. Different considerations in different jurisdictions will obviously dictate differences in the approach. Let me turn now to questions on procedure subsequent to the grant of a civil restraint order. Mr. Ng asked if the courts can extend the period for which an extended or general civil restraint order remains in effect on his own motion or if an application from a party is required. The court may exercise its power to extend the period for which an extended or general civil restraint order remains in effect on his own motion or on the application of the Attorney General or a party to the proceeding. On whether such extension is appropriate, the UK courts have considered whether there is sufficient evidence to demonstrate that there was reasonable apprehension of future vexatious conduct following the expiry of the original extended or general civil restraint order. And there's an authority on this in case members are interested in Ashcroft and Webster, which was a 2017 decision. So one of the factors which the court would look at and have regard to in the UK would be the conduct of the party against whom the orders were made subsequent to the making of the order. Mr. Ng also asked whether a party will have a right of appeal against the grant of a civil restraint order. Under Section 73 Big A9, a party against whom a civil restraint order is made may bring an appeal to the Court of Appeal with the leave of the High Court or the Court of Appeal. Finally, Mr. Ng asked if a hearing is necessary where a party is restrained under a civil restraint order, applies for leave of court to commence an action or make an application. The answer is yes, it would be. Where appropriate, the Court of Appeal, as you heard earlier, would be entitled to hear this also on paper, but it takes into account the gravity of the issue, the nuances in terms of the complexity and the novelty of the matter, and decides whether it will be assisted by oral hearing. All of these factors would come into bear. I now move on to Mr. Pillay's questions on the interplay between the civil restraint orders and Section 74, and whether there remains a useful role for Section 74. The new civil restraint orders seek to complement, but not replace, the current powers conferred on the courts by Section 74. Section 74 does provide for a suite of measures to deal with vexatious litigants and allows the courts to have the flexibility of calibrating its response to the unique challenges posed by a particular case. Furthermore, unlike the new civil restraint orders, Section 74 is not limited to civil proceedings, so it also applies to criminal proceedings, which the provisions in the SEJA bill does not do. Mr. Pillay also asked about the reason for not extending the application of the new civil restraint orders to criminal proceedings, in particular private prosecutions instituted by vexatious litigants. At present, we do not see a need to extend the operation of such civil restraint orders to criminal proceedings, given, as I said earlier, the presence of Section 74, which can be used. Notably, civil restraint orders are adapted from the UK, which only applies these to civil proceedings. If, however, circumstances change and there is a proliferation of these issues, similar issues in the criminal proceedings space, then that matter can be revisited. As for the issue of private prosecutions raised by Mr. Pillay, the control of these proceedings ultimately lie with the public prosecutor as well, and the public prosecutor can intervene at any stage of the proceedings, as I think Mr. Pillay correctly pointed out. In fact, Section 13 of the CPC, the public prosecutor has the power to discontinue for private prosecution. So to that extent, the power remains vested with the public prosecutor, and if it is vexatious and if there's otherwise any issue which causes concern to the public prosecutor, then those powers under Section 13 of the CPC can be exercised. The concern, therefore, about any potential abuse by vexatious litigants who initiate private prosecutions can be adequately addressed by or within the existing criminal procedure framework. Mr. Pillay also raised several other questions. First, in relation to the assignment of advocate and solicitor, he asked why the new provisions relating to civil restraint orders do not provide that the High Court shall assign an advocate and solicitor to the person against whom an order is sought, unlike Section 74. As I said, Section 74 now remains in its place to deal with the most severe severe of cases which attract the most severe restrictions, and it also deals with the criminal proceedings. A Section 74 order is enforced indefinitely, while a general civil restraint order, which is really the most severe of the three types of orders that we now have, is enforced for a maximum of 2 years. A general civil restraint order can be extended, but also for a maximum period of 2 years at any given occasion. Further, as I mentioned earlier, Section 74 continues to apply to criminal proceedings, and an order under Section 74 has more severe consequences in such a scenario as it can potentially affect a person's life and liberty. Therefore, having regard to all these factors, it is more appropriate to ensure that legal representation is mandated in such cases. And that's why Section 74 provides for that. Nonetheless, legal aid and the other pro bono type cases of assistance will continue, subject to the usual requirements, will continue to remain available for all parties who require but are not able to afford legal representation. I turn now to Mr. D'Souza's observation that the test under the civil restraint orders is totally without merit, while the test under Section 74 is without any reasonable ground. And I think Mr. D'Souza sought elaboration on the differences between the two tests and their objectives. Broadly speaking, the policy underpinning both provisions would be similar: to prevent abuse of court processes and allow the courts to strike a balance between giving effect to the rights of a litigant to have access to the courts, while protecting, on the other hand, the court and the counterparty from being inundated with the unmeritorious litigation to the detriment of the other party, and also to the detriment of the efficient allocation and usage of court resources. I note that it is also the case in the UK that the totally without merit phraseology or requirement is used for civil restraint orders, whilst without any reasonable ground requirement is used for the equivalent provision to our Section 74. So we borrowed from that provision and we've retained this distinction. This does not appear to have caused the UK courts any difficulty, but obviously we'll continue to watch this space as well. In conclusion, Mr. Speaker, the amendments in the bill seek to tailor our court procedures to allow our courts to function more effectively, more efficiently, and also empower them to deal with vexatious conduct as they see it occur in the context of the proceedings. The modifications to court procedures will improve the court's management of their caseload, which will go some way towards ensuring that parties resolve their disputes expeditiously, and that is also in enhancing the interests of justice. By arming the courts with a suite of measures to respond to litigants who, having had their day in court, abuse their right to be heard by pursuing vexatious proceedings, the courts will be able to husband their finite resources better and channel them to where they are most needed. There is no doubt that the improvement of court procedures is and remains work in progress. As time goes by, we can expect to see further developments, such as in information technology and the like, which disrupt the way things are done today. Going forward, we will review and continue to review the impact of the present amendments and continue to work with members to consider if further improvements ought to be made. And in doing so, we will also study the best practices of similar jurisdictions overseas to ascertain what best practices can be and should be imported into Singapore. Mr. Speaker, on that note, I beg to move.
The question is that the bill be now read a second time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Supreme Court of Judicature, Amendment Number 2 Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 20 stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. SMS.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
The Supreme Court of Judicature, Amendment Number 2 Bill.